Members, by and large, were cooperative. Today, the committee will vote on the nomination of Judge Ketanji Brown Jackson to serve as the Associate Justice of the United States Supreme Court. This is the fourth time the committee has voted on Judge Jackson in some capacity, a reflection of her extraordinary legal career. It's the first time that the committee has had the opportunity to advance the nomination of a black woman to sit on the Supreme Court. This is an historic moment for the committee and for America. During her hearing, Judge Jackson told us about her upbringing as the daughter of parents who attended racially segregated schools. She marveled at how her youth, on the heels of the civil rights movement, differed so much from her own parents' experience. Hers is a uniquely American family story. How much hope and promise can be achieved in just one generation? I'm proud we can bear witness to it. In recent weeks, members of this committee have gone through Judge Jackson's nearly 600 judicial opinions, her detailed responses to many bipartisan questionnaires, 12,000 pages of disclosures related to her time on the U.S. Sentencing Commission, 70,000 pages of materials produced by the Obama Library in response to a bipartisan request. Last week, we held 4 days of hearings. Judge Jackson was questioned for a total of 24 hours by this committee. Throughout this process, Judge Jackson has answered thousands of questions posed to her by members of this committee. In the course of this comprehensive review, a few things are clear. For one, she has impeccable qualifications. We don't agree on much in the Senate, but not one senator on this committee has questioned that she is well qualified. She has nearly a decade of experience on the bench at both the trial and appellate levels, clerked at every level of the federal judiciary, including for Supreme Court Justice Breyer. She has worked in private practice, and she served as a member of the Bipartisan Sentencing Commission. Judge Jackson would be only the second trial court judge currently serving on the Supreme Court and the first public defender ever to serve on the court. These critical experiences bring a missing perspective to the court. It is truly unfortunate that some are trying to use them as reasons to vote against her. These baseless attacks are belied by the broad support for Judge Jackson's nomination from across the political spectrum. Law enforcement, former federal prosecutors, Republican-appointed judges, and even more have vouched for her intellect, her intelligence, her ability to build consensus, and her even-handedness. On the fourth day of hearing, the American Bar Association came before us. They went through a laborious search of her record. I want to commend the law schools, including the University of Illinois, that poured through every written word that the judge has issued in her time on the bench. I also want to commend Judge Ann Williams, a former Northern District Court judge in the state of Illinois, and then a Seventh Circuit judge as well, who headed up the ABA committee. I asked her and those who were with her from the American Bar Association a basic question. Who did you talk to? And they said they reached out to over 250 individuals, judges, prosecutors, defense lawyers, co-counsels in adversarial situations, and asked them all to tell off the record confidentially what they thought of this judge. I asked about the allegation that's been made repeatedly by a few in this committee that she's soft on crime. They said there was no evidence, none, when they spoke to the group of 250 individuals. The net result of it, the American Bar Association rated Judge Ketanji Brown Jackson unanimously well qualified to serve on the Supreme Court. We've seen the evidence of her even-handedness ourselves. In her time on the bench, she has ruled for and against law enforcement, for and against immigration enforcement, for Republican administrations and also for Democratic administrations, for and against labor groups. At her hearing, she detailed the methodology she applies to ensure that she comes to each case with an independent mind. Frankly, I found her explanation far more insightful than if she had invoked contemporary labels to describe her judicial philosophy. Her methodology is one that promotes fairness, independence, and judicial restraint. It's reflected in her decision-making. In short, Judge Jackson showed us that she's committed to equal justice under the law and ensuring the Constitution works for all Americans, not just the wealthy and powerful. I was also impressed with her judicial temperament. On the whole, my Republican colleagues, starting with my ranking member, Senator Grassley, treated the nominee with dignity and respect. They promised not to turn this confirmation process into a, quote, circus, and most kept that promise. Some, however, did not. Instead, they repeatedly interrupt and badgered Judge Jackson and accused her of vile things in front of her parents, her husband, and her children. There was table pounding, some literal, from a few of my colleagues. They repeated discredited claims about Judge Jackson's record. They impugned her motives and questioned her candor. One all but called her a liar. They even suggested that Judge Jackson, a mother to two wonderful daughters, quote, endangers children. Judge Jackson is a better person than me. She stayed calm and collected. She showed dignity, grace, and poise. It is unfortunate that some moments in our hearing came to that. But if there is one positive to take away from these attacks on her, it is that the nation saw the temperament of a good, strong person ready to serve on the highest court of the land. President Biden assured the American public he would select a nominee who is, quote, worthy of Justice Breyer's legacy of excellence and decency, someone extremely well qualified, with a brilliant legal mind, with the utmost character and integrity. Judge Jackson herself characterized Justice Breyer's legacy as one of, quote, the highest level, and that's what we saw in this room last week. Rather than simply another Justice Breyer, she will be the one and only Justice Ketanji Brown Jackson. And Justice Jackson will bring to the Supreme Court the highest level of skill, integrity, civility, and grace. Throughout its history, this Senate Judiciary Committee has been the venue for some of our nation's most significant issues, debates, and nominees. I've often thought that if you had to choose one place to stand and witness the march of America, the noble and ignoble struggles of our democracy, I would seek out a chair in this room. Today's vote is such a moment. This committee's action today is nothing less than making history. I'm honored to be part of it. I will strongly and proudly support Judge Jackson's nomination. I now turn to Ranking Member Grassley for his opening remarks.
We have 6 judicial nominees, 1 executive nominee. I'll be supporting Jennifer Reardon. Ms. Reardon has spent her career litigating at some of the best law firms in the country. She's familiar with the types of cases in the Southern District of New York. Finally, take a few minutes to discuss Judge Jackson's nomination. Judge Jackson, of course, was very personable and engaging. I enjoyed the opportunity to meet her family before the hearing started. We obviously are, they obviously are, and should be proud of her achievements. Having carefully studied her record, unfortunately, I think she and I have fundamental different views on the role of judges and the role that they should play in our system of government. Because of those disagreements, I can't support her nomination. Over the last several weeks, I've talked about how the White House and Democrats have shielded important parts of Judge Jackson's record. We don't have any non-public documents from her time at the Sentencing Commission. The Obama White House held back more than 48,000 pages. Judge Jackson also gave the White House confidential, non-public probation recommendations for some of her cases. But last week, we asked for other documents having to do with probation filing in the Hawkins case. Judge Jackson told us that she can't get records for her old cases because she's no longer a district court judge. That seems to be very convenient. However, it is a big inconvenience for this senator. The refusal tells us that those documents probably wouldn't help the nominee because we've seen the willingness to leak any helpful information. So senators have to make a decision on her nomination based on the information we have. As I said, when this all started, we would thoroughly examine her record and judicial philosophy. We've done both. In the last few weeks, we've heard the remarkable arguments from Democrats that we shouldn't consider a nominee's judicial philosophy in voting. Democrats have themselves to blame. After vicious, misleading attacks on Judge Bork and other conservatives, Republicans didn't use those same tactics against nominees of Clinton, Ginsburg, and Breyer. Then, you know the history. Senator Schumer decided to bring back attacks on judicial nominees based on judicial philosophy and also on ideology. In a June 2001 op-ed, Senator Schumer pointed to Bork's nomination and argued it would be good to return to, quote, a more open and rational debate about ideology when we consider nominees, end of quote. He clearly thought the Bork nomination was a good model. Over the next few years, Senator Schumer put his Bork strategy to practice. In 2003, he even said he was proud of his role in blocking nominees based on ideology. So a question to Senator Schumer, 18 years later, are you still proud that you poisoned the water on judicial nominees? Now, he and other Democrats think it's unfair that we looked at Judge Jackson's record and asked her about it. That doesn't hold up to even the slightest scrutiny. Senator Schumer and Democrats decided to destroy the model of deference if a nominee was qualified, excluding considerations of their philosophy. In other words, Ginsburg and Breyer are models for that, and they don't think that's a good model. So that's why judicial philosophy has focused on judicial nominations. Now, at one point in written question to her, Senator Cruz posed this question: please explain in your own words the theory prevalent among members of Founding Fathers' generation that humans possess natural rights that are inherent or inalienable. She seemed to have an understanding of this when she answered by saying the theory that humans possess inherent or inalienable rights is reflected in the Declaration of Independence, which states, we hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, among them life, liberty, and the pursuit of happiness. Then in the next question, do you hold a position on whether individuals possess natural rights, yes or no? It seems to me what her understanding that she should have easily said yes to that. But she took a position, she didn't have a position. So part of having judicial philosophy is having an understanding of the fundamental principles in our Constitution. Natural rights are part of that system. But as Judge Jackson said in a written response, she does not, quote, hold a position on whether individuals possess natural rights, end of quote. I take issue with this as natural rights are basic to our constitutional system and principles of limited government. Under our Constitution, we're endowed by our Creator. Well, I don't have to repeat that. All other rights are reserved to the people under the 10th Amendment. Recognizing the principle of limited government is what makes America the exceptional government compared to all others, and obviously sets our Constitution apart from all others. When interpreting the laws and the Constitution, understanding the principle of limited government are essential. Otherwise, there would be no checks on the federal government. So does she have an understanding of the meaning of the 9th Amendment and the 10th Amendment? At her hearing and her meetings with senators, Judge Jackson explained that she does not have a judicial philosophy, instead looked at her methodology. She said to look at her cases to see that methodology worked. I did, and I found the results of that methodology alarming. when Judge Jackson applied it to the First Step Act. At the hearing, Judge Jackson testified about compassionate release provisions of the act. Senator Cotton walked through the specific cases, that of Keith Young, where Judge Jackson misused a motion for compassionate release to resentence and do it to a dangerous drug kingpin. As the lead author of the First Step Act, I know a thing or two about compassionate release. It's meant to allow elderly inmates and those suffering from terminal illness to petition the court for a sentence reduction. The statute also allows for reduction if the court finds an extraordinary or compelling reason. This is supposed to mean that it's be a rare instance and use it with great discretion, particularly as weighed against the charge, danger to society, and the risk of recidivism. At her hearing, Judge Jackson said that she based her extraordinary and compelling findings on the non-retroactive change in the law. And of course, this is a terrible and dangerous misinterpretation. Congress chose which provisions of the First Step Act would apply retroactively, and since I'm involved with that legislation, I ought to know. The Senate is currently considering legislation that I co-sponsored with this chairman, Durbin, that makes some of the First Step Act retroactive. But Congress must make that change because the First Step Act didn't provide for retroactive application in all instances. For instance, retroactivity isn't mentioned once in the compassionate release statute. The relevant sentencing guidelines don't mention retroactivity as an extraordinary and compelling reason either. So Judge Jackson's consideration of applying retroactivity to the First Step Act when it's not explicitly provided is extremely concerning. It's a radical position, and it's outside of the confines of law. Judge Jackson's interpretation was so extreme that she got Senator Cotton to even defend the First Step Act. I don't think that's what the White House had in mind when they said she was a consensus builder. The other troubling part about this case is that Judge Jackson gave a different explanation for her reasoning in the sentencing hearing than she did before the committee. She found that Mr. Young's health and COVID were extraordinary and compelling reasons that warranted the reduction in the sentence.